Yeah, so it's time. We are going live now. Okay, I think we're live.
So could you speak up a bit?
Yeah, I said we're live now.
All right.
Okay, I'll just do the introduction and then we'll take it on.
I can't hear you.
Okay, can you hear me now?
Yes.
Oh, okay. So I said I'll just do the introduction. I'll introduce you and then we'll go straight into the question and answers.
Okay, just be conscious of where your mouthpiece is located. It looks as though it
I'm
wants to
losing
shift.
you. I'm losing you.
I
Your
think,
voice is low.
can you hear me?
Yeah, better.
So I'm saying just be conscious where your mouthpiece is located. It looks as though it
Oh,
wants to
okay.
shift. Yeah, so I can hear you
Oh,
properly.
okay. Oh, all right, all right. But it's better now, right?
Yes, it is.
All right. So let us begin. I just want to drop this post on WhatsApp. Then we'll begin live now. All right. Welcome, welcome, welcome to
So
episode
much.
5 of your expert tech guide Q&A. And today is interesting because we are looking at law meets tech on the trending OpenAI, Microsoft, and Sam Altman saga. In quotes, right? All right, and with me today as a guest is Mr. Chrysolyte Egonu, Senior Associate, OAKE Legal. It's my pleasure to have you join me today.
Thank you so
So if you
much.
don't
It's
mind, you're welcome. If you don't mind, I'll just read your biography shortly.
all right.
Okay. Chrysolyte Egonu is presently a senior associate at OAKE Legal, a reputable commercial law firm based in Lagos, Nigeria. Chrysolyte leverages his expertise across industries to play an integral role in the firm's capital markets, mergers and acquisitions, finance and dispute resolution practices. With an impressive career marked by numerous successes, Chrysolyte is a trusted legal advisor who consistently delivers strategic guidance to individuals and companies across several industries. Drawing on extensive experience, Chrysolyte orchestrates complex cross-border and national transactions, as well as providing legal support to startups, venture capital, private equity deals, and investment funds. Chrysolyte's proficiency extends beyond the intricacies of legal frameworks. He is recognized for his adeptness in crafting innovative and result-oriented transaction and advisory strategies. These strategies not only mitigate risk exposure, but also secure optimal outcomes for clients. With a clap, let's welcome Chrysolyte Egonu once again.
Thank you so
Yeah,
much. Thank you so much. I'm excited
you're
to join you
welcome.
in this conversation.
Thank you so much for having me, and it's good to have you here too. Okay, so since we are working straight with 30 minutes and we don't want to waste time, we're we're diving straight into the questions. So the question one says, for education's sake and from a legal perspective, how and why do people get fired from their own companies?
All right. So thank you so much for that question. How and why people get fired from their own company. Right. So there are a number of reasons that could contribute to a person, a founder, or an executive being fired from their own company. And these reasons could range from one, the legal structure of the company, two, the employment contract, three may be the articles of association of the company. Four, it could be the company policies, bylaws, ethics, conduct, and all of that. And then also we could have normal applicable laws, right? The laws regulating the industry that may prescribe, conditions for the removal of a particular executive or a member. And I'll just try to explain some of these things while also making references to some live instances we've seen in the tech world and in the commercial space. Right. So let's discuss the very common reason why we've seen over time that founders have been exited from
Mm,
their company and fired is the
mm,
breach of company policies and code of conduct. And this mostly is related to maybe harassment, sexual harassment, fraud, deceit, and all of that. Right? We have the case of um, Elizabeth Holmes of Theranos. Right? I mean, she founded that
mm,
company, but it was later revealed that a lot was founded on deceit, a lot was founded on fraud, and all of that. We have the case of Travis Kalanick of Uber, also who
yeah,
was exited, I think, in 2017, and also this reason was tied to um, sexual harassment, a lot of complaints that had to do with the management of the company. Also, you could have the case of lack of capacity or incompetence, right? So a founder can be removed when the board decides that, oh, you're not driving the mission of this company to where we think this company should get to. And we've even seen a case where a founder voluntarily even voted against himself to say, look, I don't think I will take this company to where it needs to go to. I think that was in the case of WeWork, Adam Newman, right? And he just said, oh, this company is not becoming profitable. We have all it takes to become profitable. I'm unable to drive, the mission or drive this company to where it needs to make profit. And then again, we have a case of, the board. The board literally is the let me call it the governing center of every company that takes the decisions and drive where the company is meant to go and also not meant to go. And sometime in, I think, in the 80s, Steve Jobs also, right, was had that case with his board where his board, you know although we could say that there was a power play in that incident, but it also shows that, I mean, you could be removed by your board, right? So if the board votes and decides to say, oh, we need to remove you, you're going. Also, we have shareholder agreement. So typically founders may be party to certain shareholder agreement or other governance agreement in a company, and these agreements will typically outline the terms or the conditions subject to which a person can be removed. Oh, if X happens, then Y goes, or if B happens, then Z goes. Right. So some of these things constitute why a founder can be exited from the company. And let me just briefly talk on the how. Right. So the how a founder is removed from their company typically would depend on the governing documents of the company, the constitutional documents of the company. It could be from the articles, could be from the memorandum of association, it could be from normal the general laws governing the industry, it could be from the board charter and all of that, right? So, but mostly, if we use local requirements for Nigeria as a case study, you would find that if you want to remove such, especially where the founder is a director, that you may need to comply with certain procedures that may include informing them, giving them reason to defend themselves and all of that. But what we've seen is that in the United States it would appear that that is usually not the case. It's firing a founder looks as though it's an easier process, right?
mm,
That maybe through a phone call, through just coming, you're fired, and all of that. So, but some really, this is the why and the how why founders are exited from their companies.
Thank you so much. I think that was extensive and straight to the point as well. So I see that the structure differs from country to country and let's say jurisdiction to jurisdiction, right? Okay, so I think founders have more sort of more what's the word, leverage in this part of the world as opposed to the West.
Yeah, so
Will
the
I be
law
correct to
protects
say
them in
that?
this part of the world. Yes, the law, like particularly in Nigeria, if it's a company, you can't just say you're fired, right?
Mm-hmm.
You have to go through certain procedures, certain steps, give them opportunity and all of that, right?
Yeah. Okay. Thank you so much. I think that was straight to the point for question one, and you gave the right answers. So let's move. Question two. Question two says, as practicing lawyer familiar with organizational structure, kindly shed light on this unconventional company structure that allows for co-founder to own no shares. And this is particular to the OpenAI situation because we know that, of course, co-founders have to own shares, right? In this part of the world now, for example, you're registering your company as a limited liability, you have to own shares, your shareholders have to own shares, founders, co-founders, as the case may be. But in the case of OpenAI, which is interesting, I'd love you to, shed light on this unconventional company structure.
So in particular reference to OpenAI, it brought a certain revelation of a structure which we regard as unusual, right? And that is in the sense that typically what we see is that companies that are poised for profit,
Mhm,
in the event that they want to have any charitable initiatives, would usually
mhm,
maybe set up some charitable initiative structures to carry out, the vision of charities and all of that. But looking at
mhm,
OpenAI, the unconventional structure is tied to its inception. So OpenAI was conceived initially as a not-for-profit organization. So at the outset, the founders, the directors, the persons that were integral to OpenAI set out to say,
mhm,
look, what we want to do, we don't want to have profit as the motivating factor. What we want to
mhm,
do, we want to have the human good of the human race. We want to have charitable objectives as the primary driving force for what we want to implement. And that
okay.
philosophy, that principle sort of guided their structuring of the company. So OpenAI started out as a not-for-profit organization, right? So what
Mhm,
this means
mhm,
is that we are not here to make profit. We just want to
yeah.
implement what we want to do and then go on. But eventually, as time went on, they found that they couldn't be funded sufficiently to do all they needed to do. So, but having that primary philosophy at the back of their mind, they then
Mhm,
said, oh, we will not let go of this philosophy, but we will try alternative structures that allow
mhm,
us, move the company to where it needs to be while also
mhm,
maintaining the mission and vision statement that we had. And that's why we now
mhm,
saw this unconventional structure. So that background is very important to understanding what happened when you say, oh, how come a founder or a co-founder has had no shares in the company? So what is this
yeah.
unconventional structure? It was such that the open AI, which was a not-for-profit, now incorporated a profit-making entity. That is, I think, OpenAI Global LLC, right? So OpenAI Global LLC
Okay.
was meant to be the profit-making arm of OpenAI Incorporated. And the structure
Mhm,
was such that it was subsumed to be under the not-for-profit structure. What this means is that the governing mind and the directing mind of the profit entity was going to be the not-for-profit entity, such that it would infuse that philosophy of, human good, charity, and all of that to the profit-making entity. So what
mhm,
this now brought about was that the the board of directors of the not-for-profit entity we are prohibited from taking up shares in the profit entity, right? And even the persons that held shares in the profit entity, they were restricted or limited on voting on certain matters. And this was to avoid a conflict of interest situation, right?
mhm,
So the and then additionally, the structure they added was that they limited the amount of returns that an investor could make in the profit entity. And all
mhm.
of this was geared towards the fact that they didn't want profit to be driving their core,
Yeah,
their core mission. You know what
yeah,
happens when
yeah,
profit
yeah.
is driving the core mission of an enterprise?
Uh-huh.
You may have cases of them doing whatever they can do to just make
True,
money,
true,
right?
true,
And
true,
so they
true.
wanted to avoid that. So now this, I think, in my view, this also
Mm-hmm.
led to the founders not taking up shares. right? To say,
Mhm.
oh, if we don't take up shares or if we don't have such maybe controlling shares, we're just focused on the mission. So
Yeah.
initially, this was fully a mission a statement. It was fully
Yeah.
a mission focused venture, and so that's
Yeah.
why we see that particular structure in OpenAI. Because of time, I'll just wrap it up here.
Wow, wow, wow. I think this is profound. So I want to ask, right? So moving forward, and let's say someone needs to, or someone is considering, taking up this kind of structure. Is it worthwhile? Like someone in Africa, let's say I see someone now, sorry, a company and organization is considering this OpenAI structure, maybe by virtue of their mission being in sync. I mean, is this something you advise? Is this kind of structure something you advise?
So usually, right, and like we've seen from this case, there are companies are open to implement a variety of structures to further their business objectives, right?
Mhm.
So it would depend on. So it's usually not a case of copy what has been done before. It's usually
Mhm.
a case of implement what will suit your business objective. So if you think,
Mm.
you may think that, oh, I want to implement this structure while having at the back of your mind that, oh, I need money, or I need to make money, I need to be profitable, I need to.
Uh-huh.
So it will only depend on what the business and the mission statement of that business enterprise is. That will then
Okay.
determine how or what structure would be recommended, right? It will determine the structure
Yeah.
that will be recommended. But definitely, this situation gives an insight and opens us to the possibility of a structure that can be implemented, right? And
Mm.
it could
Mm.
be adopted by a similar company that has that wants to run its business in that structure, but it will be
Yeah.
subject to the laws, the governing laws. So
Yeah.
for instance, if it's a company in maybe Nigeria, Ghana, Kenya, you while that structure is good and that would have worked in the US legal system, you want to
Mhm.
find out, does your local company laws allow or permit you to implement that type of structure? So it will be depend it's on a case by case basis usually.
On a case by case basis. I get that on a case by per time and what laws apply to where you are. All right, let's run. Question three says, what are the underlying legal considerations arising from Sam Altman's exit and speculated return as CEO of OpenAI? Now, for those of us watching, OpenAI are the owners of the artificial intelligence AI software ChatGPT. So I was reading today before the show, and I noticed that I think on Wednesday, Sam Altman had returned to OpenAI. I really don't know if you did some confirmation on that, but well,
Yes, so this opens up a lot of issues, right? It's not, it wouldn't usually be like a walk in the park, as though just you've gone, you've come back. Now, if what has happened was that the employment or the engagement of Sam Altman, or the CEO of OpenAI at the time, had been terminated, right? It opens up a um, legal whole new legal issues, and one of such is that it questions legally the capacity of the board to govern the company, right?
mm,
So there is the it could be the shareholders could determine that, oh, we have lost confidence in the board to govern the company if they're taking such decisions where they're letting someone go and they're allowing the person come back. It's there is the confidence effect on the ability of the board. Secondly, it opens up what are the bylaws or governance practices of the company, right? You could find that a company's articles, charters, bylaws do not permit an exited CEO to return, right?
mm,
So once
mm,
someone has been fired, you cannot re-employ. So firing a CEO and trying to bring them back, you would want to consider whether the my governing laws, the bylaws, the
mm,
articles today would it usually permit that type of action. The next thing it opens up is there is the potential, it has a potential of opening up litigation and a suite of disputes, right?
Mm-hmm.
So it could be from the perspective of the CEO that is returning, and maybe the terms of the negotiations for his return. It could be in the case of even an invested shareholder saying, oh, okay, if this guy has gone, we should not be taking this guy back, and then that guy takes out an action. It could even be a minority protection action to say, oh, the decision to bring this CEO back to the company is not one that we agree with. So the company would have exposed itself to such dispute and litigation issues. Then also it brings up the issue of maybe renegotiating new terms, right? I
Mm-hmm.
would
Mm-hmm.
assume that, I mean, I would assume that the Sam's return wouldn't be on the former terms as when he left, right?
Mm, mm,
So
mm,
it could be, and that could bring some cost perspective for the company, right? So say he was being paid $150,000 per week. He could, if you want me so badly now, so I could be asking for 250. And so
mm,
it has raised the running cost of the company in that regard. Also, it has an effect on the employee morale, and we saw it when he left, right? Where all
true.
the employees said, "Oh, if he's going, we are going with him. If
Mm-hmm.
something is happening, right?" So it has all that effect on the employee morale. Then generally, you also want to consider, beside the the company charter and all of that, whether the laws governing, the corporate laws, the company laws, the industry specific laws, whether they permit such type of move.
Mm,
Today, does it permit you, someone that has been terminated, and being returned? Then lastly, you also want to find out what the impact of that exit and return has on the prior employment contract, or contract of engagement or executive contract. So primarily these are some of the issues, considerations that arise from Sam Altman's exit and speculated return as the CEO of OpenAI.
interesting, interesting. Because I mean, even whilst I read today, I noticed that I think over 70 employees, were threatening to either leave or have him come back, and people were
Right.
like, "So this would leave him with that Superman kind of, I can
Right.
do no wrong kind of feeling." Yeah,
Yeah. So additionally, let me even add. So additionally, let me just add the last point. An implication to consider is, what is then the impact on the board's ability to oversee his actions? So what we
Exactly.
see is, like you've just mentioned, now what we see is someone who has gotten his way, right?
Mm-hmm,
Typically, by the
mm-hmm,
structure of companies, a board is meant to supervise the CEO and say, oh, you're not doing this right, oh, you can't do this, oh, you're fired for this. So is this a case of the CEO becoming bigger than the board which is
mm,
meant to supervise him? So you now may have a spiraling effect, where
mm,
the new board that has been consisted is now constituted. They are now afraid. I mean, we can't fire this guy.
mm,
The last time we tried
mm.
it, he returned. He had this way. The employees will leave. So they are just basically just dummies, right? Just look and say, okay,
Right.
just right. So it throws that up also.
Yeah, I mean, these are pros and cons, right? Okay,
Yeah.
so to question four, the last. So we have, according to data from GCPA, GCPA is a website too, that's like the acronym, for April 26, 2023, we have, according to this data, that Africa's tech ecosystem has attracted unprecedented levels of capital over the last several years, with venture capital VC investment reaching nearly $3.2 billion in 2021 and $2.8 billion in 2022. What practical steps should founders and co-founders, using Africa as case study, take to protect themselves from getting fired from their companies? All right, so we have like the next 7 minutes, so we just take it up and then you put your last words and then we'll wrap up.
Okay. So thank you so much for that. So practical steps to. So let me just start by giving this prefatory remark. The reason a founder or co-founder will find themselves in the space where their continued existence in the company is threatened is because,
Mm-hmm.
one, they are looking for funding, or two, they've taken up funding, right?
Mm.
So I would say, as much as possible, if you can run your company without external capital, try to do that.
Mm.
If you
Mm.
come to the place where you're running your company without external
Mm.
capital, nobody is trying to, come
Yeah.
into your company to direct what you're doing. So you're running your
Mm-hmm.
company, you're running your vision, your money,
Mm-hmm.
and all of that is working. But then I also acknowledge that it's not in every case that typically and usually, right? Companies would have to raise capital. Now,
Mm-hmm.
but I will say this very carefully, because from experience, it can be a bit difficult to find a situation where you, what I would propose, most of them, except you're very good in negotiating. But the first thing is, founders should pay attention to their shares, pay
Mm-hmm.
attention to board seats,
Mm-hmm.
attention to voting rights, and pay
Mm-hmm.
attention to reserved matters. And I'll just
Mm.
explain briefly, right?
Mm.
The controlling mind of your company is in the board, right?
Mm.
The board decides what happens, the direction the company takes, and all of that. So if you will be fired, is the board that takes that decision. If the company will spend X amount, is the board that takes that decision, except it's a reserved matter. If you're employing or paying this out, the company takes that decision. So when I say pay attention to board seat, it's what I mean is let's assume that the board seat of a company is five, right? And they are
Mm.
voting by way of simple majority. It means that if a vote is cast and three persons on the board vote for a particular decision, that carries the vote, right?
Mm.
So you want to ensure that the persons on your board are such that they understand the mission and the goal of what you're doing, and
Mm.
you've done enough due diligence on them to ascertain that, oh, let me say, they are on your side.
On your side.
Also, you want to ensure that you have board seats. Your interest is represented on the board, and what that would
Mm.
translate to you having board seats on the board. Now, board seats naturally would translate to voting power, right?
Mm-hmm.
Again, sometimes founders look at their shares without also
Mm.
looking at the underlying things behind, or the shares. So let me just
Mm.
give a practical example. So let's say your shareholding is, you have 60% shares, right?
Mm-hmm.
And your
Mm-hmm.
investors have 40. Ordinarily, what that will look to you is that, oh, you have the majority to vote, right? But
Mm.
then what if you have 60% and somehow you've negotiated poorly, and that 40% investor has the most seats on the board?
Mm.
Remember, where the decision happens is in the board, right? So you
Yeah.
need to pay attention to where the decision happens. That's where you
Mm.
control, that's where
Mm.
you block all of
Mm.
these things, right?
Mm.
So
Mm.
you want to know
Mm.
that, oh, even if I have 20% of the shareholding, I'm well
Mm.
protected in the board. My board seats
Mm.
are very protected. Another
Mm.
thing you need to do not negotiate away those board seats. So these are very connected
Mm.
issues, and I've hampered a lot
Mm.
on board seats, right? Do not
Yeah.
negotiate away, your board seat. Then the
Mm-hmm.
next thing the founder wants to do is that,
Mm-hmm.
if you can no, just pay attention to the class of shares that your investors have. So you may have people that
Mm-hmm.
have preference shares, you may have people that have different categories of shares, right? So
Mm-hmm.
what you may hold is could be ordinary shares, in the sense
Mm-hmm.
that it only and your investor has, maybe, for instance, Facebook, right?
Mm-hmm.
Zuckerberg had what we call super voting shares, such that
Mm-hmm.
his vote could carry more weight, even than more than those of the investors. I mean, this is
Mm.
not
Mm.
usually a typical situation, but he
Mm-hmm.
had that type of shares. But we find arrangements where your investors have either the preference voting rights, they have the super
Mm-hmm.
majority, they have the most seats on the board. In that situation, you're technically out of it. So when you're negotiating, maybe your shareholding agreement, your share
Mm-hmm.
subscription agreement, and all other suites of agreements that allow an investment in your business venture, you want to ensure that this is protected. Then also, another thing to recommend is, go tilt towards impact funds, right? So these impact
Mm-hmm.
funds are not like, let me say, the core VCs that we know that are just
Yeah.
focused on the money, taking control. Sometimes you might find some that align mostly with your vision, right? And all they
Yeah.
care about is making that impact, and not so much as to, doing this thing they do where you take over your control and all of that. Then also,
Mm-hmm.
what I would recommend is, usually you could implement term limits. So
Mm-hmm.
it could be by your board charter, it could be in the articles, it could be in the shareholders agreement, right, where you have board
Mm-hmm.
limits for independent directors, such that, if you get to so number of years on the board, you're exited. So it helps you keep
Mm-hmm.
some form of control around the
Mm-hmm.
investors. They're not sitting in for so long. They can go, they can come. Also, what you can do where you're unable to, let me say, even get board seats on the board, you could get what
Mm-hmm.
will have observer seats,
Mm-hmm.
right? So those observer seats may not allow you vote, but they give you an insight into what's happening in your board, what direction your board is taking, where they are going, and all of that. And then maybe lastly, because of our time, just have a
Yeah.
general code of conduct for the board, how it will run,
Mm-hmm.
practices, and all of that. So I think briefly, if you implement some of these things, they
Yeah.
will help you control and manage, your position in the board and secure your place.
Wow, 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 wow. This is profound. As you're talking, I just know we are pressed for time, But this is very interesting. And we're even having more people join us. I mean, we have
Right.
Ayomide Ayileka says where the
Yeah.
decision happened. Like when you were listing your point, it's very powerful, and you just had to drop a comment. We see you. I think we should have a comeback for this. Yeah, I think we'll have to talk that offline, really. Like we just have a founders, co-founders timeout. What do you think?
Right, right,
Yeah,
right.
I think we should really, maybe before the year runs out, to have a comeback episode. This is fantastic. Thank you so much. I know we are
Thank
pressed
you
for
so much
time.
for having
I
me.
absolutely appreciate you. This is enlightening, to say the least. We are going to have a comeback definitely. So please, guys, just click the subscribe button before you leave, and share. On episode 5, we're talking about we are going to have a cybersecurity analyst at Union Bank, and the title is interesting. You see, cyber analyst at Union Bank versus Japa, 5 scary things you didn't know. I mean, episode 5 is packed. So just subscribe, and then we'll see you there. Thank you so much, Chrysolyte Egonu. It's been a pleasure having you on episode 4, and we're super excited. Thank you, thank you,
It's been a
thank you. We
delight
can't
discussing
appreciate it
with
enough.
you. Thank you for having me on this program. Thank you so
You're
much.
welcome. You're welcome, Chrysolyte. Thank you. Bye
And,
bye.
and thank you to the listeners, the guests, and everyone that joined in. We don't take it for
Yeah.
granted. Thank you so much also.
Yeah,
All
to all
right.
our listeners, more comments are coming in. Like more comments, more comments. We see you, one Peter Collins. We see you all. We see you all. Shalom Idagu. We'll have a founders and co-founders section definitely. I will keep you in touch. Please subscribe, turn on the post notification, and we'll see you soon. Bye bye.
Thank you.